We, the people of the United States,
in order to form a more perfect union.
This is a very dangerous time.
Establish justice, ensure domestic tranquility.
Provide for the common defense.
Promote the general welfare.
The agenda of the radical right is incredibly extreme.
And secure the blessings of liberty.
Since September 11th, the Constitution has been stood on its head.
To ourselves and our posterity.
It really speaks to what we believe America is all about, and this affects everyone.
To ordain and establish
this Constitution
for the United States of America.
The framers, they'd seen a country ruled by tyrants. They insisted on one ruled by laws. They were right. Over 2 centuries, our Constitution, laws, and courts have preserved freedom, equality, justice, not just for the powerful, but those with no power. Infallible? No. Indispensable? Absolutely. But over the past 25 years, an increasingly influential movement of ultra-conservatives has waged a quiet war on this vision of the law.
They believe that the government ought to have vast power to invade our lives and little or no power to protect us, particularly the most vulnerable among us.
By overturning decades of precedent, ultra-conservatives aim to dismantle vital laws, wage a culture war,
as critical to the kind of nation we shall be as the Cold War itself,
expand presidential power.
Do I have the legal authority to do this? And the answer is absolutely.
An unpopular agenda hidden beneath a torrent of political rhetoric.
Activist judges, activist federal judges.
An activist judge.
This is the one phrase, judicial activism, that gets everybody on their hind legs.
I don't believe in liberal activist judges. I believe in strict constructionists.
The out-of-control judiciary, and this was in your last book, Courting Disaster, is the most serious threat America has faced in nearly 400 years of history. More serious than Al-Qaeda, more serious than Nazi Germany and Japan, more serious than the Civil War?
George, I really believe that. I think they are destroying the fabric that holds our nation together.
What they have said is that our judges will just follow the law, and that they are strict constructionists who won't legislate from the bench. Exclamation point.
Would strictly interpret and apply the law.
They're not going to legislate from the bench.
Should interpret the law and not make it up.
And the strict interpretation of the law.
And that has been phenomenally effective. It's a lie. It's not the case that they're just following the law.
Judicial conservatives have gotten the idea that maybe a little bit of judicial activism or a lot of judicial activism is really okay as long as it's judicial activism for the causes they believe in.
What seems to typify their view is activism when it helps their cause and restraint when it helps their cause.
They call themselves conservative. Their goals are not.
What would happen if Clarence Thomas and Antonin Scalia got their way? What is their sort of vision for America? And if you say to people what their vision is, you know, say goodbye to workers' rights, say goodbye to environmental protection, say goodbye to women's rights, say goodbye to the rights of the disabled, you know, say goodbye to all the progress that we've made in terms of race and gender in this country and privacy.
This would be a program of constitutional revision, which is pretty much unprecedented in our nation's history. If they succeed, we will, without really seeing it happen, end up with a very different country, one that's both less free and less equal.
How did all this start? Many date it to 1964. Barry Goldwater, a Republican candidate from the extreme right.
I would remind you that extremism in the defense of liberty is no vice.
Goldwater lost in a landslide, but his defeat galvanized ultra-conservatives. They didn't get that far with their agenda, though, until 1980.
Do solemnly swear. I, Ronald Reagan, do solemnly swear.
They moved aggressively under Reagan, led by people like Attorney General Edwin Meese and young lawyers like Samuel Alito. If there was ever any doubt about what they planned, that disappeared in 2002 when law professor Dawn Johnson exposed documents that made it crystal clear.
The Reagan-Meese memos were issued by the Department of Justice in the 1980s to set forth a blueprint for radically moving constitutional law to the right by overruling a series of landmark Supreme Court decisions on all the great issues of the day.
Meese didn't act alone. Ultra-conservatives had partners on the outside, big business and big money. They poured millions into law schools, into think tanks, into nonprofit law firms, and into a group called the Federalist Society. It began as a forum for debate. It turned into a way to groom lawyers for high government office and the federal bench. And there were more allies, allies on the religious right. They said to change the law, you had to change the courts.
Amen.
And what you saw beginning in the early 1980s was really a coming together of conservative ideas, conservative intellectuals, conservative lawyers, and conservative money, all pointing in one direction. And the direction was, let's get the people we want on the courts.
1987, an opening on the Supreme Court. Ultra-conservatives thought they had their man. Judge Robert Bork scorned the right to privacy, called constitutional precedent not all that important, and even opposed the principle of one man, one vote.
I think, Senator, I not only wrote that, I still think I was right.
Americans rejected Judge Bork's ideas, and the Senate rejected his nomination.
Leniency in the courtroom and the fashioning of new rules to protect criminals.
After Bork's defeat, ultra-conservatives pushed their agenda behind a barrage of buzzwords.
Who support judicial restraint.
Put people on the bench who are strict constructionists.
Judicial restraint.
Interpreting the law, not writing it.
Will interpret the laws.
Won't legislate from the bench. More strict constructionists.
Interpret the law and not try to
legislate from the bench.
They also learned how to package their nominees.
Now I think they pretty much have a script.
It would be best that I not comment.
It would be improper for me to express a view.
And I don't want to comment on the correctness or incorrectness.
I have no quarrel, Senator.
I don't have any quarrel with that conclusion.
Then I have no quarrel with it.
Have an open mind.
Every case with an open mind.
I would approach the question with an open mind.
There is significant weight to be given to existing case law.
It certainly is a precedent of the court.
My job is to take those precedents seriously.
Say as little as possible. Speak in generalities when you can, and when you ask for specifics, try to dodge.
We no longer have candid, revolutionary efforts to change the American Constitution as we know it. We rather have a stealth revolution.
I believe the Constitution protects the right to privacy.
You're not suggesting that there wasn't any discussion at any time of Roe versus Wade?
I cannot. Senator, I cannot remember personally engaging in those discussions.
Justice Thomas, when asked about Roe against Wade, said he had never talked about it to anyone. And then, of course, when he gets on the bench, he makes his position absolutely plain from the get-go.
I don't have any objection or basis to object, or at this point any quarrel with the way that the court has interpreted the interstate commerce clause.
Ultra-conservatives perfected the spin and put judges on the bench.